Welcome to part three. If you have not seen the prior two videos, I recommend that you watch those first. I am talking about the most important document in your real estate transaction, which is the purchase agreement. This video is about title and escrow, which is part three of the purchase agreement. It's a short one, but I wanted to show you some samples because I feel like there is less communication sometimes with escrow officers and less questions directed towards me, or more questions directed towards me, or I feel like that sometimes this part can be overlooked by buyers and by sellers. Okay, so title and escrow. Usually, obviously, you're not going to send the money directly to the seller, right? You're not, even if it's a cash transaction, you're not going to give cash to the seller. You're not going to deposit directly to his account. We're going to do escrow. This contract shall be used as escrow instructions. The escrow company employed by the parties to carry out the terms of this contract shall be. Right here, I have pre-filled out this probably because in some listings the real estate agent has already started escrow. If there is something like probate, they might already have all of the documentation. If this was maybe an investment property, they might already have all of the documentation that will be required. So if this is pre-filled out, it is usually because the real estate agent requested that we utilize their title and escrow. As a buyer, you should know that you have every right to shop your own title and escrow company. These items can be shopped for. Okay, so you do not have to use exactly what the seller tells you. However, sometimes some things may be complicated, as for example, somebody that's going through probate and maybe all of the documentation has already been started with a title company. Maybe they have a power of attorney or something for the seller. So sometimes they're actually asking for that for a specific reason. Sometimes they're just asking for it because the real estate agent, the listing agent, wants to do business with that specific escrow officer. Otherwise, I'm going to use my preferred escrow officer, whom I have great communication with. Again, as a buyer, you have every single right to use the escrow officer that you wish to use. If your cousin is an escrow officer and you want to use that, feel free to do that. You have every right, right? Sometimes I notice that if you select your own escrow officer, the real estate agent and the seller, they're going to counter with the one that they already want, and then they explain to us the reason. Anyways, this is going to be their information, their email, the phone number, and usually their address, their office address. Title investing. Buyer will take title as determined before close of escrow. If buyer is married and intends to take title as his or her sole and separate property, a disclaimer deed may be required. Taking title may have significant legal, estate planning, and tax consequences. Buyer should obtain independent legal and tax advice. A lot of buyers overlook this. Okay, maybe you're married and maybe this is investment property to you and your wife does not want to be involved. So she is going to have to come to the closing and sign a disclaimer deed and bring her identification, so on and so forth. Maybe you're not married, but your girlfriend is going to help you pay for the property and you want her to be on title as well. So both of you guys are going to have to be on the purchase agreement and both of you guys are going to have to attend closing. You can't just add her on and not have her sign for all of this. Depending on estate planning, if you're a seller and you're going to make a significant amount of money, you need to be talking to obviously somebody that does your taxes and possibly somebody that does legal stuff for you if you have a trust or anything of that nature. Okay, so several instances of the purchase agreement asks you to consult with an attorney and to consult with your tax advisor. This is one of the instances. Also, you're going to receive, usually there's 10 ways to take title in Arizona. You can take title. There's different ways to take title, and I highly suggest that you have this conversation with your escrow officer. If you were to pass away, do you want your house to automatically transfer to your children? Do you want it to transfer to your spouse? Do you want it to transfer to somebody else that's going to be on title, so on and so forth? So have that conversation. Do a little bit more research so that you know what ways you can take title. Title commitment and title insurance. The escrow company is hereby instructed to obtain and deliver to buyer and seller directly, addressed pursuant to 8S and 9C, or as otherwise provided, a commitment for title insurance together with complete and legible copies of all documents that will remain as exceptions to buyer policy, title insurance, title commitment, included but not limited to conditions, covenants, and restrictions. I'm going to show you an example of this: deed restrictions and easements. Buyer shall have 5 days after receipt of the title commitment uh, um, to provide notice to the seller of items disapproved. So this section gives you another opportunity to cancel the purchase agreement if there's something that you do not like. And I'm gonna point out to you what you should be looking at, because you might not like specifics to the property that you're purchasing. Let's just say that you receive a plat map of the property that you're going to live in. Okay. You have to pay attention to easements. I'm going to get closer to this. Are there any utility easements? So let's just say that you're looking at a property that's not fenced, and you're thinking, I'm going to fence it. And let's just say that, let's pretend that there was an easement and it's a utility easement where TEP or Southwest Gas has to be able to access that, and you cannot fence that property. How would you know unless you received this document that shows you the easements? How would you know that you cannot build a fence, right? So these are conversations that you have to have with your real estate agent. If maybe you like the property and you're thinking, I'm going to build a fence around this. This is awesome, right? Um, that conversation has to be had with your real estate agent so that she can be or he can be aware of what easements there are to your property, so that you're not stuck later on having to provide access to TEP or Southwest Gas or whatever. I'm going to give you an example of some easements in the cookie cutter homes, right? These are typically homes with HOAs. If you notice, right next to the sidewalk, there's usually like an electric, like a big electric box, and maybe like some smaller things that are usually cable or electric or gas or whatever. Or you might even see like the water meter and a bunch of stuff like that. That is considered an easement. Not all homes, not all subdivisions have their easements right there. Sometimes, if it's a corner lot, it might be on the side. So keep in mind what an easement is and why it is important to you, and why plat maps are important to you as well. Do a little bit of research, inform yourself as to what easements are. I can give you another example, and this is prevalent here in Arizona, where you have a lot. Let's see if I can access this picture. It's downloading something, but anyways, you have a lot. Let's just say that this is your lot, right? And that your house is right here, and there's another house right here. And let's just say that there's a road that the neighbor has to go through to be able to get to their house. That is considered an easement. So, do you want that in your property? Because you might be looking at this property and thinking, this is so badass, and this is a lot of property. I love it. I'm going to fence it. And maybe you can't, right? And maybe nobody explained to you that you can't. And maybe you buy the property, and as soon as you start fencing it up, the neighbor's like, hey, what the F? What's going on here? Why are you like removing my access to my property? Like, because it's my property, who cares? And they're like, no, but there's an easement. And when you purchase the property, you agree to the easement. And maybe you're like, what do you mean I agreed to the easement? Well, you accepted the property with an easement. And here you are, really angry at somebody because they didn't explain to you that your property has an easement that provides access to your next door neighbors. There's a lot of real new real estate agents, and you might be utilizing them because it's your sister, your cousin, your tia, your nana, whatever. And maybe they don't know how to explain this yet. So just watch out for this. If you're not utilizing me as your real estate agent, you should be. But ask, ask your real estate agent, are they familiar with easements? What is an easement? Does a property have any sort of utility easements or whatever it may be? Because some people might look at a large lot and they might be thinking, yes, I can build out. I can make a pool right here. I can maybe add a shed, or maybe I can build a workshop. And maybe you can't. and maybe you don't know, because maybe like in this little map right here, you want to make the workshop right here, but you can't do that because that's an easement. And yes, maybe it's a curve and it's weird and it should be a straight line. But those things, those changes should be made while you're doing the purchase, prior to purchasing, because maybe you are stuck and maybe you're gonna have a fit or a fight over changing this type of easement. Okay, so that's why that is important. Most of the time, you're going to receive packages from the title company, and usually they are encrypted. They're folders. You have to create a password. And a lot of people don't like this because it's changed and it's overwhelming. And you're already reading all the purchase agreements and you're already doing all the loan stuff. So, as a buyer, typically you get overwhelmed because there's so much information coming from three different ways, that you might overlook some things. So this is something that you should maybe take into consideration, that you will be receiving is like plat maps and stuff like that. Okay, so if you're not seeing that, be aware, just pay attention. These are other forms of easements, right, where you have to be able to access a wetland. That's not very common in Arizona, but if you just Google easements, you're going to find a lot of photographs that might explain stuff to you. Declaration of covenants, conditions, and restrictions, especially if there's an HOA. If there's an HOA and you want to know if you can plant an olive tree there, it should be able to. You should be able to find that in your conditions, restrictions, rules, bylaws, regulations of the HOA. Can you paint your house pink? Can you paint your house purple? Is that allowed? No. Are they giving you approved swatches so that you can paint your house in that manner? Yes. Can you park a car outside of your sidewalk? Sometimes, and I noticed this when I purchased my house, sometimes that is not spelled out in the conditions, restrictions. So you might be able to fight something. For example, I started receiving letters that I can't park on the street of my house, and I was like, you know what? I'm a real estate agent. I read the conditions, the restrictions, and all of that, and there's nothing specified about parking on the street. There is a specification that we cannot have commercial vehicles on our driveway. However, there's nothing stating that I can't park on the street. So those are the documents that you do not receive from me. I receive them as well, and I will probably point them out. But you should be paying attention to this so that nobody overlooks this. Okay, so that's why that's important. That's an important part of this section. And all of this mumbo jumbo that most of us don't understand, that is what it's talking about. Those are the documents that it's talking about. The CCNRs, the title commitment, additional instructions. The escrow company shall promptly furnish notice of a pending sale that contains the name, address of buyer to any homeowners association, right? They're going to do that transfer. They're going to do all of the disclosures and all of that for the HOA. Escrow company is also acting as a title agency, but is not the title insurer issuing the title insurance policy. Escrow company shall deliver to buyer and seller, upon deposit of funds, a closing protection letter from the title insurer indemnifying the buyer and the seller for any losses due to fraudulent acts or breach of escrow. Instructions by the title company. All documents necessary to close this transaction shall be executed promptly by seller and buyer in the standard form used by the escrow company. Escrow company shall modify such documents to the extent necessary to be consistent with this contract. Escrow company fees, unless otherwise stated herein, shall be allocated equally between seller and buyer. So remember, guys, if you guys need, and so if you guys are coming into agreement and the buyer says, you know what, I will cover everything in escrow, this has to be added to additional terms so that the escrow company is aware that all of those fees have to be allocated to the buyer. And this usually happens with investors. That's not very typical if the buyer is obtaining a loan, but just know that that can be done. Escrow company shall modify such documents to the extent necessary to be consistent with this contract. As escrow company fees, unless otherwise stated here, shall be equal. Okay, I already read that. Escrow company shall send all parties and brokers copies of all notices and communications directed to the seller, buyer, and brokers. Escrow company shall provide brokers access to the escrowed materials and information regarding the escrow. If an affidavit of disclosure is provided, the escrow company shall record the affidavit of at close of escrow. I'm not going to go into the affidavit of disclosure unless you are in an unsubdivided area in Tucson. Okay. Explorations, you're going to notice and you're going to get a ledger. And I'm not going to put it on here because it's just going to confuse you further. But you're going to notice that a lot of things are prorated. Assessments and fees, assessment and lease, all of that is prorated. And you're going to see that on a settlement statement. The release of earnest money. So if you decide to cancel this contract, or if you are the buyer and you breach the contract, the seller cures you, and you don't comply with their cure notice, or you can't ask for an extension or something like that, you don't come into agreement, and the seller gets your earnest money, the escrow company has the ability to release that earnest money. And the buyer and the escrow authorize the escrow company to release the earnest money pursuant to the terms and conditions of this contract in his sole absolute discretion. Okay, so buyer and seller agree to hold harmless and indemnify escrow company against any claim, action, or lawsuit of any kind, and from any loss, judgment, or expense, including costs and attorney fees arising from or relating in any way to the release of the earnest money. Okay. Again, in most of these sections, it's telling you seek legal advice. I always recommend my clients to at least get Legal Shield, so that if there's anything that you have a question about, you can reach out to them and they can explain everything in lawyer terms. If you can't afford an actual lawyer, because they do tend to be expensive. So anyways, that summarizes section 3, which is mainly title and escrow, and the documents that you should be receiving. And if I ask you, hey, are you married? I'm not hitting on you. I am asking you if you're married because I want to know how you want to take title and who's going to take title. And maybe you're going to take title with your daughter, and maybe you're going to take title with your father. So we need to have these conversations with the lender, as well as who can be on title and how is it going to affect the mortgage, right? And also, if you are an investor and you don't want your spouse to be to have any interest in the property, there has to be disclaimer deeds. A disclaimer deed basically means that the in the case of a divorce or whatever, that person has no interest in that property, meaning that they can't actually take that from you, right? If you have any questions, again, my phone number is 520-249-7029. You can find my information easily online as well if you want to get my email. I rarely respond to YouTube comments, so please if you have any questions, just reach out to me. If you don't have a real estate representation yet, please reach out to me. I would love to be of service to you. My name is Adriana Valdosova, Coldwell Banker. I hope this was informative. And I'll see you on video number 4, which is all about disclosure.